now a 3-2 majority, with 3-1 majority on the NLRB. And so they've really gone hog wild on trying to kill us. And by that I mean any business. And one of the symptoms that we've seen, excuse me, is what they tried to do to Boeing in South Carolina. They try to open up a plant, give thousands of people jobs, but they say it's retaliatory against the unions in Washington, none of whom will lose any jobs, and who have struck so frequently that Branson now doesn't want to give Boeing any more orders. Sounds like a good business plan to me. And the NLRB has now passed rules requiring that we post union posters, that we apprise our employees of their unionizing rights. I think nobody has been successful so far in unionizing a school in our sector. To my knowledge, we beat one last year that was pretty nasty. But the NLRB has gone that way. One positive thing, at least on that, they've mitigated this social media thing a little bit. Excuse me for encroaching on the positive side. This is at least some shining light. They've taken the position that if what the employees are griping about on Facebook is about their individual gripe, that's okay. You can can them for that. But if they're griping about other people's stuff, then you can't can them for that. Everyone get that? Everyone perfectly clear on what you can do? See, I'm a simple guy. I know if I saw that stuff on Facebook from my employees, I know which problem I want. They're going to become former employees. Not that I'm a hardneck. Now, the class actions are still a plague in the wage and hour cases, in particular in California. There's not as many of them on the student side, but as anyone who attended the seminar yesterday with my partner Julie Vogelzang heard, it's so easy to mount a wage and hour class action, particularly since the laws are so easily violated and easily violated in groups, and the money involved is so tremendous that we're defending a very large number of these wage and hour class actions. But again, without encroaching too much on the positive side, the Supreme Court this year in a case called Concepcion against ATT said that any state law which attempts to limit, in arbitration that is, the ability of a business to ban class or mass actions is invalid because it's preempted by the Federal Arbitration Act. So federal law trumps state law in this instance. So California had a rule that said that in most instances, unless the claim was big enough or wide enough, any rule attempting to ban a class or mass action in arbitration was invalid under state law. And what the Supreme Court, this is the US Supreme Court did, is sweep that away. Now there's an attempt to cut back on that. Certain claims, exotic claims called private attorney general claims, which don't have damages but have penalties attached, have made it through, at least in the appellate courts. But the plaintiffs' lawyers are really wringing their hands on this one. It's the death knell for these wage and hour class actions. Now, it's going to take some time. For those of you, it won't apply to those of you who don't use arbitration provisions in your employment agreements. There's good reasons to do it, good reasons not to do it. One of the good reasons to do it, obviously, is the fact that you can now ban class and mass actions. That means people who sign such a provision, assuming it's properly prepared, have their case and their case only. Now, if you owe an employee $32.83 in back wages, you think there's going to be many plaintiffs' lawyers wanting to take that case? No. So if you take away the incentive, you take away the problem. Now, the same thing is true in student class actions as well, and even more so. Unlike employment, where probably only a portion of the folks here have arbitration provisions, virtually everybody in the room has an arbitration provision in their enrollment agreement. If you don't, you shouldn't. And until recently in California in particular, we've not been able to ban class and mass actions. And it's the class and mass actions that are the really big threat, because the plaintiff's lawyer can sign up 100, 200 students, and this is happening. We've got cases with well over 100 students in them. These aren't class actions. These are group actions where there's 100 different plaintiffs in there, in the group going after the school. Then you're dealing with people who have nothing to lose and who can group together and lie like a Greek chorus about all the bad things we supposedly said to them. But the fact is, if you can break these up in individual one versus one claims, all these former students who promiscuously sign up and say, sign here, I'll get you all your money back, have to prove their case one at a time. You think the likelihood that we've made a mistake across 100 or 200 students? Very likely? No, not likely at all. And if you make the plaintiff's lawyer spend money that he's got to try every single case, right? He gets paid on the come, right? He gets paid only if he wins. If you take away the economic incentive to file case after case, it spikes the recruiting. And the tendency in these cases, we've got a very large number of these, 150, 180 of them teed up for the next year to try one after the other, and it's had a significant impact in doing this. So that's a pretty big deal. So that the ability, unlike our employees, right, who aren't going to sign new arbitration agreements until they're replaced or there's something else rolled out, each new student is an opportunity to put a new arbitration agreement in place. So if you haven't already modified your enrollment agreements to include a ban on class or mass actions, to require that it be your case and your case only, give me a call or an email. We'll send you, I'm not going to charge anything for it, send you our most current provision. It's state of the art. You won't lose on this thing. And then if someone comes after you, it's their case and their case only. And it makes a big deal. And on the negative side of what Ed has pointed out, the Brinker case, the issue in Brinker is whether you have to actually force people to take meal and rest breaks, unpaid meal and rest breaks, or whether the opportunity for these employees to take the breaks is sufficient. Do we have to be the policeman of our employees, or is simply being a conscientious employer and making the breaks and meals available sufficient? And that's the case that's been pending 3 years for the California Supreme Court, but it's set for argument in November, and the Supreme Court has a rule that they have to decide the case within 90 days of the date that it's argued. By the way, if they don't do it, they don't get their paycheck. So you see, economic incentives really do work.
I don't know, some of that seemed like positive news to me, but all right, so I'm back now to the positive side on student claims. As Keith was mentioning, the Supreme Court case that impacted the employee side also has profound effects on the student side. Turns out that the arbitration agreement that Keith created and we've been proselytizing about for years and years now has been interpreted uniformly to prohibit class actions brought by students. So if you've been following that advice and you've got arbitration agreements in your enrollment agreements, then you should be good to go on this front. Second, even though litigation is way up in California, student litigation, turns out that litigation is really limited to very narrow areas. Culinary schools are getting hit hard, also ultrasound programs, and some of our more specialized medical programs are having trouble.
The downside is that there's 3 groups of lawyers out there, 2 of whom are competent, 1 of whom is not, that are filing these claims. And they're filing them in very, very large groups. And these are groups of well over 100 individuals. And even if done the way we're suggesting them, they're terribly expensive to defend. And having been defending student claims a very long time in this sector, oddly enough, this is a down, but not as much of a down. There were times where there were dozens and dozens of these cases widespread across all sorts of programs. Now, the quality of disclosures at the front end, at least, in terms of transferability, no guarantee of job, no guarantee of salary, all the good stuff that we've been building for years has made it very difficult to bring those sorts of claims. The sorts of claims we're seeing now have, except the ones on the culinary side, have much more to do with the lack of a particular programmatic accreditation with CAPPS or JCERT. And so they tend to be fairly limited claims. But from that bright side to the downside here, and I do this litigation defense nationally, and not just in California, the trend in each of these cases is now to focus like a laser beam on the accuracy of disclosed placement statistics. And this is the area in which, as a sector, we've done a rather rotten job as compared to what we've done on the admissions side. And by that I mean on transferability, salaries, all the other good stuff that we're very careful about disclosing. We've made that wall just hard as heck, but because we've pressurized, particularly in recent years where the economy has gone kind of soft and sour, we pressurized the heck out of the career services side. And many of us have not built up the kind of robust fact-checking and verification mechanisms. And as a result, some of the disclosures, and this has been in the paper, obviously, some of the placement disclosures, the numbers of how many people were placed in a particular job or occupation are turning out to be not as accurate as hoped. And every judge, jury, arbitrator, layperson who would decide a case of a student versus school will believe that a decision to enroll will be materially affected by the placement statistics given out by the student. And with the GE disclosures now, it's raised to a much higher level of danger and difficulty. For one thing, it's on our websites, right? Now, these may be accreditation statistics, these may be bureau statistics, but now they're available to everybody. And if those are inaccurate, there's a claim that you're in violation of federal law, which can give rise to False Claims Act issues and liabilities. So the greater level of disclosure that we're giving gives us greater risks on the side of accuracy. And so if you haven't gotten religion about making certain that your placement statistics are absolutely stone cold, verifiable, no question about it, accurate, now's a good time to go down into the bowels of the Career Services Department and make sure they're as accurate as they are pressurized. The accreditors aren't kidding about this. They're issuing actions and concerns to the extent that your annual reports aren't accurate. The plaintiffs' lawyers are all over this. And in previous years, we've been very successful at keeping the placement statistics backup, the names and outcomes, out of the hands of the plaintiffs' lawyers using FERPA and other sorts of privacy arguments. But those are getting less successful as the plaintiffs' lawyers get more experienced, and what you see is they're required to give out notice that that information will be given out. So you have to assume that that information is going to be transparent. If you haven't hardened yourself up in career services on accuracy, now is the time. The other thing is that the demagoguery at the federal and state level, coupled with bad media treatment, is definitely fanning the flames of negativity and litigation. We're seeing this in Kentucky, where Conway has been leading the charge and was the first to intervene in the case against EDMC in Pittsburgh. We see it even with Kamala Harris here in California, jumping on the bandwagon over there with EDMC, and it's atrocious. And that trend is going to continue. They all smell money, they all smell publicity, and they can all continue to say bad and rotten things. And the more bad, rotten things they say, the more people are likely to believe that those bad and rotten things are true. How many of you, in talking with friends, neighbors, people with whom you're acquainted, and talking about what your business is, now will talk about what you do and hear a negative comment that 2 years ago you might not have heard? Anybody? Okay, the same people, are you getting those negative comments from people you actually respect? People who are critical thinkers and are repeating this garbage as if it were true? Unfortunately, and I see Avi shaking his head, I mean, this is true. If you repeat this ugliness long enough, people believe it, and it's infecting arbitrators, it's affecting judges, it's affecting juries, and it's causing people to bring claims. The plaintiffs' lawyers see the dollar signs, they think they've got a target sector, they think we're an easy target, and they're going to continue. And that's the bad news. This isn't going to go away anytime soon. This type of litigation is going to get worse because the politicians won't shut their mouths, and they're not going to shut their mouths for some time.